I'm reading on SHU. All right, this is case number 234467301, the people of the state of Michigan versus Kaylee Ann Shu. Defendant is charged with one count of disorderly conduct. Today is the day set for sentencing. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. Joanne Prey on behalf of Ms. Shu, P number 66127.
Ms. Shu, please unmute and state your full name for the court.
Kaylee Shu.
Today is the day set for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the pre-sentence report, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our end.
What about that for page 1? There was no plea agreement?
There was, Judge. I was going to wait to address that at sentencing, but there was a plea agreement, Your Honor. I don't believe, and that's on my mistake, that the people gave a written plea agreement for the court file, so I don't think there was one in the court file.
Okay. So what was the plea agreement?
So the plea agreement, Your Honor, was for the original charge, assault and battery, to be reduced to a disorderly person. The people did have an opportunity to speak with the complaining witness, and that is how we came up with this particular resolution. There was a recommendation from the people for 12 weeks of anger management, no contact with the complaining witness, Ms. Alyssa McLaughlin, and the people had no objection to a delayed sentence.
All right, anything else?
No, Your Honor, that's all for the people.
All right, with respect to additions, deletions, or corrections, are there any on behalf of the defense?
Your Honor, I just wanted to indicate the same thing that Ms. Ritter did, that this was, we asked for this to be considered under 771.1, that if successful completion, this be dismissed at the end of the term of probation. I did want to address within the PSI.
Say that again.
Within the PSI, I believe as part of clarification or addition, if you will, I know it notes on page 7 that she's in a sorority with this individual, which I believe kind of makes it sound like she is having contact with her. Ms. Shu is graduated. She didn't have anything to do with the sorority since her sophomore year. And I just wanted that to be clear, because when I read that, it sounded like these are people that were going to be interacting and having contact with each other through this sorority. And that hasn't been the case for over 5 years. So I don't know if there could be a notation that Ms. Shu has not been involved in the sorority for over 5 years, just so that's clear that they're not going to be having contact with each other.
I didn't get that when I read it, but okay.
And Your Honor, I did want to address the dilute test as well as some of the terms and conditions at the appropriate time.
Ms. Ritter, anything from the people with respect to sentencing?
Your Honor, with respect to sentencing, I see that there was a recommendation from probation for 9 months. I'm actually going to ask the court, due to the original nature of the charge, that be amended to 12 months probation, with the understanding that Ms. Shu is eligible for early discharge at the 6 month. On page 4, under victim statement, it looks like probation tried to reach out to the complaining witness and was unsuccessful. The people have been in constant contact with the complaining witness prior to today's sentencing day. She had all the information to appear at sentencing, and she also received information regarding restitution. I do understand that she has some co-pays with some medical bills that she was supposed to submit to the people. However, we did not receive that. So the people are, I guess at this point, satisfied if the court sets restitution at 0, because we have not received any information for the restitution. But other than that, Your Honor, the people have nothing further as far as sentencing.
All right, with respect to sentencing on behalf of Ms. Shu.
Thank you, Your Honor. I did want to address the dilute test. Ms. Shu does not have an issue with drugs or alcohol. I would ask if the court is going to require testing, that should be allowed to attest immediately. That will be negative, and that the court not order any continued drug screening. I know that Ms. Shu has been extremely nervous throughout this entire process. I know she was very nervous before this, and I think this is a situation where she overdid it with water. I would also, understanding what Ms. Ritter asked, I would ask that the court consider that this offense occurred over 2 years ago, that she was arraigned in June of last year, that she's had no issues with the court or with the complainant during that entire time, and that she works over 40 hours a week. She works from 8 to 6, 5 days a week, and perhaps the court would consider a shorter term of probation and or decreasing the community service. Regardless of what is ordered, whether it's anger management or a drug test, whether or not that could be done in Troy, where Ms. Shu lives, and or if she could report via Zoom and or telephone if the court would allow. I know that I've had, over the course of the last 2 years, she retained us when this incident occurred. I've had the opportunity to meet Ms. Shu, to discuss this case with her at length. She is a very smart, articulate woman. This is completely out of character for her. She has shown the utmost regret and remorse over this incident, and she's going to do everything to prove this to the court, that she's going to move on with her life and you're never going to see her again. Respectfully, I would ask that the court grant leniency and consider our request for modifications to the recommendation. Specifically that she not have continued drug testing, that she be allowed to show through one test that she doesn't have any issue with drugs or alcohol. And I know she would like to address the court as well.
All right, Ms. Shu.
Sorry. I just want to start off by saying that I'm really sorry. This has just been weighing very heavily on me for 2 years now. I'm very ashamed, I'm embarrassed, and it's not an accurate representation of myself and my character. I've never been in trouble before. I'm not going to be in trouble after this. And I know that you'll never have to see me again. And I regret the actions that I made. And I'm looking to move forward from this. And I am prepared to do whatever the court asks of me as well.
Okay. All right, as I indicated, the court has had an opportunity to review the pre-sentence report. I am ready to impose sentence. I'm going to read something before I impose sentence. And anyone who has practiced in front of me for any even short amount of time, and especially people who know me personally, and everyone knows that I believe in chances. I believe in not just a second chance. I believe in a lot of chances. I believe that people have to be given grace to sort of make mistakes. People have to be given grace to get it right. There's no, when we're born, we don't get a book that tells us this is what you're supposed to do to live. And then some things are mistakes and some things are horrible choices that we make. And even in making horrible choices, sometimes we make horrible choices. Even in making those horrible choices, there's still room for grace. But I want to read something, then I'm going to impose my sentence. So when I was reading, and I'm also going to say this, of course, I don't know Ms. Shu personally. And so when I'm reading, or when I'm trying to know who you are, I'm just reading your resume of sorts, right? It's a resume. People's life become their resume. And your contriteness is noted. Your remorse is noted. But I'm going to read something, then I'm going to do the sentencing. And I'm reading on page 4. And I'm reading the police description of the offense. And I'm reading beginning at the sentence, starting with a struggle ensued. So it says a struggle ensued, and the defendant Shu grabbed the complainant McLaughlin by her hair and slammed her head into the concrete floor. Bar security broke up the fight and escorted both outside. The complainant sought medical attention for a concussion. And then on the next page, it says the witness Eads observed defendant Shu slamming complainant McLaughlin's head into the floor. Witness McGlitch observed defendant Shu pouring a beer over complainant McLaughlin's head, then assaulting her. So I'm sure we all can agree that wasn't a mistake. That was a horrible choice. And then, one can say that an individual doesn't engage in drugs or alcohol But, being an individual who tries on a regular basis to meet my daily water intake goal, I know that if I meet my daily water intake goal and I go take a drug test, my urine is not gonna be, diluted, too diluted to engage in a urine test. You have to drink an awful lot of water to dilute your urine. And when an individual's urine is diluted, it is generally, usually, most often, an intentional act. We don't slip up on diluting our urine. It's not an accidental dilution of the urine. And I've never heard, I think this might be the first occasion that I've heard of nervous drinking water. I'm nervous, so I'm drinking water. That's about the first time I've heard that in my 57 years of living. In my 17 years on the bench, I never heard anybody get nervous and they say, I'm gonna drink water. But it could happen. So all I know is that a urine test was ordered and then the urine test came back diluted. In my mind and in my eyes, a diluted test is a positive test every single solitary time. Every time your urine is diluted, I assume that you're gonna test positive for marijuana, alcohol, cocaine, heroin, and everything that's possible. Okay. So having said that, I don't know if the victim, because now we're post-conviction, but I don't know if the victim decided that they didn't want to, they didn't care about whatever the medical expenses were. Maybe perhaps, they decided to move on. Ms. McLaughlin decided to move on. Maybe her insurance covered the whole thing. But what I read in the pre-sentence report is an atrocity. That's just a shame. That's like one of those situations where people try to go back and get you back. You slam my head into the concrete, you poured beer on me. That's one of those things that if I, the person, the victim, if I'm not the type of person that is either forgiving or understands you shouldn't take the law into your own hand, that's the kind of situation where you try to get the person back. That was some horrible things that you did. And I appreciate the fact that you're sorry for that. But what your resume says is that you're capable, right? Sometimes when you go to a job interview, you try to convince a person, I'm capable, I can do that. I'm capable of managing a 50-person team. And the reason that I'm capable is because look at what I've done before. When a person is faced with a situation and they make a decision about that situation, that speaks to that particular person's character as to how they handle that particular situation. If somebody come and slap me in the face, it's gonna speak to the type of person I am if I haul right back off and slap them back, or if I try to say, oh, okay, let me find out why they slapped me in the face. You made a horrible decision on that day, and I don't know what the argument was or what the situation was, but it says a lot about your capabilities. All right. So having said,
Your Honor, may I address one thing? I'm sorry.
no, ma'am.
Thank you.
Having said that, the court is going to impose the following sentence. I am going to accept the people's request and increase the probationary period from 9 months to 12 months with the understanding that Ms. Shu has an opportunity for early discharge after 6 months. The court will set a final review date of February 24th, 2025. At 10 o'clock a.m. if we get to that point. But the midway review will be August 22nd, 2024 at 1:30 p.m. with the following terms and conditions. Ma'am, you shall not violate any criminal law, any governmental unit. That means no new cases. You must not leave the state of Michigan without consent of this court. You must make a truthful report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following: fines, costs, and fees. You will pay $210 mandatory costs. You will pay a $500 fine. Court sets restitution at 0, having received no response from a victim. You will pay $420 supervision fees. That is at a rate of $35 per month. If you are discharged early from probation, that particular condition will be prorated. The court imposes a $50 pre-sentence investigation fee. You will submit to random your analysis once a month for the first 3 months. The court will impose $30 for urine test. However, you may test at a location more convenient to your home. The $30 is only for testing at 36th District Court. If you test at a location more convenient to your home, the $30 is removed, but you have to pay that agency directly, regardless of their fee. That's not my issue. We charge $10 here at the court. If you need something more convenient to go somewhere else, you have to pay their fee, whatever their fee is. But you have to test. The test is random. The test is random. The nature of the test is random. Therefore, if they tell you to go on Monday and you show up on Tuesday, don't do it. Don't waste your money. You've already missed the test. The nature of the test is random. I will only be interested in the results from the day that the random test is pulled. So if they pull your name, if they pull your color, if they pull your number, and that says come on Tuesday, and you go on Thursday, I don't want the test from Thursday. Any diluted test is a positive test. It is a positive test. Any diluted test is a positive test. I am only ordering urinalysis for the first 3 months. If there are no positive tests in the first 3 months, then probation will discontinue the testing. The total fines, costs, and fees are, let me see. I believe it's $1,210, but let me see if that's right. Yes, $1,210. In order to be discharged early, you have to have paid $1,000 because the court will back out the supervision fee. So in order to get discharged at the 6-month mark, you have to have paid $1,000 of the $1,210. Additionally, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management. You shall attend the Choices program through eBay. There was a recommendation for 5 days of community service, but I'm ordering Choices instead. I'm not going to order the 5 days of community service. You should have no contact with the complaining witness. And there was also a recommendation not to consume alcohol. I'm not going to, honor that. Additionally, I will, despite the fact that I don't know why this deviation was given. Let me be clear that I disagree with the deviation that was given. It appears to me that the original charge was aggravated assault. And then it should have been perhaps deviated down or reduced down to assault and battery. Let me just say, I'm not the prosecutor's office. She has a right to charge whatever she want to charge. That's her business. It's not mine. I'm just noting for the record, I disagree with the deviation. All right, we are gonna mail a copy of this order to the Seminole Street address or the Seminole Drive address, and then probation will contact you at the phone number ending in 4866. Is there anything else for the record on behalf of the people?
Not from the people, Judge. Thank you.
On behalf of the defense?
Yes, Your Honor, is the court allowing this under 771.1?
I apologize. Thank you, counsel. Yes, I will. That's what I was getting ready to say when I went on a tangent about I didn't agree with the deviation. I was gonna say, despite me not agreeing with the deviation, I am going to sentence Ms. Shu pursuant to 771. Therefore, Ms. Shu, if you complete the terms and conditions of the probation, even if you get discharged at the 6-month mark, then the matter will be dismissed. It will be removed from your record and the conviction will no longer stand. Anything further?
No, Your Honor, thank you.
All right, then we're all set. Have a great day. Stay safe.
Thank you.
Thank you.
You're welcome. Okay, I'm gonna do, Van and then, Williams, LaDasia Williams in that order. So I'll do Van first and then LaDasia Williams in that order. Ms. Ritter, did you talk to the witness that says on Haley? You talked to that witness?
I did not, Judge. I just renamed her because I noticed that she was in a, I just noticed she was in a breakout. In the waiting room.
Is that defendant? Yes, okay. Let me bring that witness. This is not. Ms. Tran?
Yes,
Okay, I'm ready. Can you state your name for the record and raise your right hand, please?
my name is Thuy, Thuy. Last name is Tran, Tran.
Do you swear or affirm that you will translate? Is this Vietnamese, right?
Yes, it is.
Okay. Do you swear or affirm that you will translate from English into Vietnamese, anything I say, counsel says, or the clerk says, and from Vietnamese into English, anything Ms. Van says to the best of your ability?
Yes, I do, Your Honor.
Okay, and I guess I should say with regards to the case. Evelyn Jones, I'm gonna send you to a breakout room. Please accept to join the breakout room and then wait for the prosecutor to come in to speak with you. Please do not leave the breakout room until the prosecutor has come in to speak with you. Okay, with respect to Van, this is case number 14062-87601. The people of the state of Michigan versus Gay, Thai, Van.
Hôm nay đây là Đến lượt phiên xử của vụ số 140628601 của người dân Michigan đối với bị cáo là Gái Van.
The defendant is charged with one count of gambling, disassociated person, and today is the date set for an arraignment on a bench warrant.
Hôm nay ở đây có một cáo trạng là đánh bạc và hôm nay là ngày tháng để cho thông báo bản án.
Ms. Stevenson, your appearance, please.
Janice,
Bà Stevenson thể nói tên.
Janice Stevenson appearing on behalf of Guy Van.
Janice Stevenson sẽ thay mặt cho Gái Van.
Can
Ms. Van,
say her name for the record?
Cô bị cáo hãy nói tên cho hồ sơ ghi lại.
please unmute and say your name, Ms. Van.
Chị Văn, chị bật cái micro lên và nói tên lên ạ. Chị bật mic lên rồi nói tên đi ạ. Không nghe thấy đâu chị, cái micro của chị chưa bật chị ơi.
Alo, nghe chưa?
Nghe được rồi.
Dạ, em là Văn Thị Gái.
My name is Văn Thị Gái.
Thank you.
Cảm ơn.
Okay, today is the day set for an arraignment on a bench warrant. As to the arraignment on the bench warrant, Ms. Stevenson.
Hôm nay sẽ là ngày thông báo bản án đối với cáo trạng tại trước chánh án.
Dạ.
Thank you. Ms. Van stands mute, waives the reading of the information. We ask that a plea of not guilty be entered on her behalf that we immediately proceed to review.
Chúng tôi đã xem xét cái lời nói là không có nhận tội và sau đó chúng tôi đã tiếp tục để hai bên chúng tôi đã tiếp tục để xem xét lại cái vụ việc.
Dạ.
All right, the court, as to the arraignment on the bench warrant, enters a not guilty plea, and we will move immediately to review.
Okay, chúng tôi sẽ xem cái cáo trạng trước chánh án là xem xét cái lời nói là không có nhận tội cũng như là tiếp tục để xem xét lại vụ việc.
Yeah.
There was an order of delayed sentence entered on June 4th of 2015 by Judge Robbins.
Ngày mùng 4 Tây tháng 6 năm 2015 thì chánh án Robin đã đưa ra một cái bản án và cái bản án đã được hoãn thi hành.
Yeah.
Ms. Ms. Van was ordered to pay $450 by June 4th of 2015.
Bà cô Vân đã được ra lệnh là phải trả $450. Hạn chót là ngày 4 Tây tháng 6 năm 2015.
And to return to court on June 6th of 2016.
Và cần phải quay lại tòa vào ngày 6 Tây tháng 6 năm 2016.
Without having any contact with any casino.
Và không được phép có liên lạc với bất kỳ một casino nào, một cơ sở đánh bạc nào.
The Register of Actions indicates that the $450 payment was made on June 4th of 2015.
Hồ sơ ghi lại rằng là khoản tiền $450 đã được trả vào ngày 4 Tây tháng 6 năm 2015.
I am unaware of any allegations of violation of the no contact with casinos condition.
Tôi cũng không có thấy rằng là có cái sự vi phạm nào được ghi lại đối với việc cái lệnh là không được liên lạc hay là tiếp xúc với bất kỳ một cơ sở đánh bạc nào.
Ms. Van admits that she did not return to court on June 6th of 2016 with an explanation.
Bà Văn đã thừa nhận, nói rằng là đúng là bà ta không quay lại tòa vào ngày 6 tây tháng 6 năm 16 nhưng có giải thích tại sao.
While she does acknowledge signing the order of delayed sentence,
Cái bà ấy có công nhận rằng là đã ký cái bản thông báo là có cái sự hoãn thi hành án, cái lệnh hoãn thi hành án.
she indicates today that she did not understand she had to come back to court on June 6, 2016.
Nhưng mà bà có chỉ ra rằng là bà đã không hiểu rằng bà cần phải quay lại tòa vào ngày 6 tháng 6 năm 2016.
She does not recall that information being translated at the time of the plea.
Và vào cái thời điểm mà tòa xử và nói là nói là có tội hay không có tội đó, thì bà nói là không có nhớ rằng là cái lệnh là phải quay lại tòa vào 6 tháng 6 năm 2016 thì đã được dịch cho bà, không có nhớ là người ta đã dịch cho mình cái điều đó.
On, I believe, January 24th of 2024, Ms. Van did post a $2,000 cash bond.
Và tôi thấy rằng ngày 24 tây tháng 1 năm 2024 thì bà Văn đã nộp bảo lãnh tại ngoại là $2.000 tiền mặt.
We would accordingly ask the court to dismiss this case.
Bởi vậy là chúng tôi xin tòa là cho hủy cái vụ này đi.
Pursuant to MCL 771.1.
Theo điều khoản của MCL, điều luật số MCL 77.1.1.
If the court is not inclined to dismiss the matter,
nếu mà tòa không muốn hủy cái vấn đề này đi,
we'd ask the case be closed at this time, Your Honor, and that the bond be refunded.
Thì chúng tôi xin đề nghị tòa là khép lại vụ án này và cho phép cái tiền bảo lãnh tại ngoại được trả lại.
Thank you, Your Honor.
Xin cảm ơn.
The court had an opportunity to review the register of action. The court agrees with the defense. The court will dismiss the matter with prejudice.
Và tòa đã xem xét cái hồ sơ ghi lại và hủy vụ này.
The court will refund the last bond posted as the payment was made by the deadline date.
Và tòa sẽ hoàn lại cái tiền bảo lãnh tại ngoại theo trước thời hạn chót.
The court will mail the $2,000 bond to Ms. Van at her address on file with the court.
Thì tòa sẽ gửi bằng đường bưu điện cái tiền bảo lãnh tại ngoại lại cho bà Vân tại địa chỉ mà ghi lại trong hồ sơ của tòa.
If you do not receive within 4 weeks, contact the court.
Nếu mà bà không nhận được cái khoản tiền này trong vòng 4 tuần nữa thì có thể liên lạc lại với tòa. Yes.
Any further?
Nothing on behalf of Ms. Van. Thank you, Your Honor.
Tôi không có thể bổ sung thêm gì nữa thay mặt cho bà Vân. Cảm ơn.
Cảm ơn.
Thank you.
Ms. Van, you're all set. Have a great day. Stay safe.
Cái vụ của bà đã xong rồi. Chúc một ngày tốt lành.
Cảm ơn nhiều.
Thank you very much.
You're welcome.
Thank you, Your Honor.
Have a great day. Stay safe. Thank you.
Thanks. Bye-bye.
Ms. Ritter?
Yes, Your Honor.
I thought you had someone here for the Williams case in the waiting room. I don't see them.
I did, Judge, and I don't see him either.
Okay. It's not one of these. It's not one of these now unidentified people. Well, they're identified, but I mean, I'm saying it's not one of these people.
I don't think, no.
Okay. Good morning, Mr. Blake.
I'm checking in on Tolbert.
Yes, did you say good morning to me?
Did I say good morning?
Yeah, I said good morning, Mr. Blake, and then did you say good morning back?
I did, Judge. Even with the sore, I said I managed to get out a good morning to you.
Oh,
I-
that's so,
I always-
because I like for you to say good morning. I'm sorry, okay, you said you're checking in on Torbert?
Yes.
Oh, okay. Oh, okay, yes, I see it. Okay, then I'll be with you shortly. I'm getting ready to, this one case, and then I'll be, and, you'll be next.
Thank you, Judge.
Welcome. Okay. Then I'm ready on, LaDasia Williams. This is case number 234534601. The people of the state of Michigan versus LaDasia Darmani Williams. The defendant is charged with one count of moving violation causing death. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. And from my understanding, Your Honor, there are family members that are present in the courtroom. So at the court's direction, I would ask the family members to state their names for the record.
That's not necessary. Is
Okay.
there one representing the deceased?
From my understanding, I believe Mr. Lion King, the deceased complainant witness's son, is the representative of the family.
Is Mr. King present?
Yes, ma'am.
Okay, you can state your name for the court, please.
My name is Lion King.
Thank you.
No problem.
All right, Ms. Stevenson.
Thank you, Your Honor. For the record, Janice Stevenson appearing on behalf of Ms. LaDasia Williams. Ms. Williams, ma'am, please unmute and please say your full name.
LaDasia Williams.
Okay, today is the day set for a final pretrial conference. How are we proceeding?
Your Honor, at this time, Ms. Williams will continue her plea of not guilty. Your Honor, we would ask the court for a brief adjournment of the final pretrial conference. We just have to finalize a few things with regard to this matter, Your Honor. It is our full intention to resolve this matter short of trial, but we just would ask the court for a brief adjournment, Your Honor, not more. I wouldn't need more than 2 weeks, but we would rest on the convenience of the court, Your Honor.
Do you still have on March 7th, do I still have a head start? Abdul? I don't know. I can't.
Yes, Mr. Berman.
What's the last name? Is it Abdullah?
Abdullah.
Oh, okay. What's the first name?
Abdul.
And they still on there. They have a final. Never mind, strike it. So how many do I have? I have 28. That's how many. What's on 14?
31.
Oh, but 5 of those are in Africa, right?
Yes.
Ms. Stevenson, no, okay. So you said you don't need, you wouldn't need more than 2 weeks. So if I put this on for 2 weeks, because I guess I have I guess I have, oh wait, how many reviews do I have? Do I have reviews that day in the afternoon on Saturday?
March 7th. Yes. 2, 4.
So of the number that you gave me, 4 of those are afternoon reviews.
Yes.
Okay, so let me see. Okay. All right, March 7th. Does that work?
Yes, Your Honor, March 7th is fine, and we thank the court.
Court is going to continue a not guilty plea on behalf of Ms. Williams. I will continue the matter to March 7th, final pretrial conference. If the matter is not resolved on March 7th for the final pretrial conference, I am going to set a trial date. I'm not gonna adjourn I'm not gonna adjourn, final pretrial again without a trial date, because my trials are filling up, so.
Understood, Your Honor. Thank you so much.
All right, final pretrial conference, March 7th at 9:00 a.m. All right, unless there's something else for the record, we're all set.
Now from the people, Your Honor, thank you.
Nothing on behalf of Ms. Williams. Thank you very much, Your Honor.
All right. Have a great day. Stay safe. All right, I'm gonna do Mr. Blake's case, but I'll bring in, these other people that you want me to speak to, and then you can talk to them. Is Haley here? Yeah, okay, so I'm gonna do Mr. Blake's case, and then I'll do Haley. And then I'm gonna release this witness on Stacker. All right, so let's see. The witness on Stacker is gone.
I see them in the waiting room. They're second on my waiting room list, Your Honor.
What's their name? I see it, okay. All right, and then. Oh, Ms. Stevenson, I don't think I sent you anything on the reviews. I'll have to look, I'll look.
Okay.
Does anyone know, am I missing it? Harrison? Where is that at? Oh, yeah. Oh, I said, Ms. Stevenson, did you all already talk to Harrison?
No, Your Honor, Ms. Harrison's audio was not working when I went into breakout room.
Okay. What about Starks Harris? I thought. Oh, he was the one on the phone. Okay. All right, Ms. Harrison, let's try again. I'm gonna send you to the breakout room. All right, good morning, Ms. Coppich. You are the complaining witness on a case involving Marquita Stacker. Ms. Stacker has not appeared today. And it is now 10 o'clock, so I'm going to, has she taken this before?
Yes.
Well, on the 22 case, but what about on the 23 case?
No, you don't know.
Oh, ma'am, I'm talking to my clerk. I'm talking
Oh,
to
I'm
my-
sorry.
Well, 23 cases were like December 21st. First time.
You said both. Shoot.
Oh, I'm sorry, just the one, yes.
Okay. All right, so I'm going to be adjourning the case. To let's adjourn the case to March 27th.
When you say no teachers.
And if she doesn't appear that day, then the case will be, I'm sorry, if she doesn't appear that day, then the judge will revoke her bond and issue the habeas, putting a warrant out for her arrest. If you want to come on March the 27th to see what happens, you can. If not, the prosecutor will let you know, okay?
Yes,
All right, then have a great day, stay safe.
thank you.
You're welcome.
What time?
8:30.
Thank you.
You're welcome. You know, that's 8:36. Mr. Starks, I need you to get stationary. I need you to be seated in an upright position and ready to attend court. I need you to get stationary. I'm gonna send you to a breakout room, Mr. Starks. Please accept to join the breakout room and wait for the lawyers to come in and speak with you. Please do not leave the breakout room until the lawyer has come in to speak with you. Ms. Ritter, why did you go off camera? You're not the prosecutor on, oh, don't say, she gonna be, oh, that's because you were young, okay. She was like, Judge, because sometimes you gotta turn off your camera for a minute.
I just had to stretch out a little bit, Judge.
Oh, what just happened to Mr. Right Blake? He was just here. Did he? All right, well, now we have to wait for Mr. Blake to come back. And then if Mr. Blake is on tour, why is Ms. Stevenson's name there? Did he?
That was in here.
Okay. All right. I don't know what happened to Mr. Blake just right there, but. I guess he's trying to log in. Now, I do, you know, maybe, look, maybe he has AT&T,
Oh, yeah.
because that's gonna be a mess. Okay, well, I guess we'll wait for. In the meantime.
His office kind of let him know.
He looked like he was in his office.
Yeah.
Oh, let me tell you who's covering for me. Ms. Hall,
Yes, Your Honor.
all right, what are you ready on?
I am ready on Haley, Harper, McLawn, Simmons.
Hey, look, I wasn't gonna write them all down. Let's go with Haley. Haley. There's some light shining on your face that makes me not able to see your face. Can you, turn a little bit maybe away from the window? Okay. All right, I'm ready on Jones. That's not what I meant. I'm ready on Haley. All right, this is case number 234423001, the People versus Makia. Deshay, Meche Haley. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for, pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I also have the complaining witness, Ms. Jones, present via Zoom this morning. Ms. Jones, unmute yourself and state your name for the court.
My name is Evelyn Jones.
Thank you.
Good morning, Your Honor. Vakidia Hall, P number 82954, on behalf of Micaiah Haley. Ma'am, may you state your full name for the record?
Micaiah Misha Haley.
Thank you. Today is the day set for pretrial conference. The complaining witness is present. How are we proceeding?
Your Honor, Ms. Haley would like to continue her not guilty plea and set this matter for a final pretrial and also request discovery.
The court will continue a not guilty plea on behalf of defendant Haley, set the matter for a final pretrial conference. April the for the 25th. April the 25th. At 9:00 a.m. Discovery should be submitted by March the 25th. Bond will continue with no contact between the parties, no contact with Evelyn Jones. With respect to the April 25th date, Ms. Jones, you are not required to appear, but you may appear if you want to. You may appear at any scheduled court appearances, but you're not required to appear April the 25th. If you do not appear, then you could contact the prosecutor's office to see when the next court date is and whether your appearance is required. Anything further with respect to this matter?
Not for the people, Judge. Thank you.
Nothing for Ms. Haley. Thank you, Your Honor.
Then you're all set. You both are all set. Have a great day. Stay safe. I'm ready on, are you ready on Allen Robinson? Or Alziadi?
I'm ready on Allen Robinson.
Oh, there's Mr. Blake.
I'm also ready on Al-Ziadi.
So I'm actually gonna do Alziadi first because he's been here already for a long time. Mr. Alziadi? Mr. Alziadi? All right, he's not ready. I'm ready on Allen Robinson. Oh, okay.
Yes, ma'am. Sorry about that.
Okay, because I'm just getting ready to pass your case, but this is case number 224405601, the people of the state of Michigan versus Zane Raji Alziadi. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Rakidia Hall on behalf of Zain Al-Ziadi. Sir, may you state your full name for the record?
Zain Labadin Raji Al Ziadi.
Today's the day set for pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of the complainant, and if the court is not inclined to dismiss the matter at this time, we have no objection to an adjourned pretrial requiring the complainant to appear.
Ms. Ritter?
So, Your Honor, I don't see the complainant witness, Mr. Ali Al-Nam, in the waiting room. In addition to that, Your Honor, I do see notes in my system from our victim advocate services that the complainant witness reached out to our victim advocate, Mr. Moore, on February 20th of 2024, and he expressed that he no longer wishes to prosecute this case. So at this time, Your Honor, the people will not be able to proceed based on the complainant witness's refusal to prosecute.
All right, people have indicated that they are unable to proceed as the complaining witness does not wish to prosecute the matter. The court is going to grant defense counsel's motion to dismiss the matter, failure of the complaining witness to appear, and refusal of the complaining witness to cooperate with prosecution. Sir, we will mail you a copy of the order of dismissal for your records. Have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. All right, I'm ready on Allen Robinson. This is case number 214532201, the people of the state of Michigan versus Joshua Allen Robinson. The defendant is charged with 1 count of operating while intoxicated, 1 count of failing to stop at a collision damage accident. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Joshua Allen Robinson. Sir, may you unmute yourself and state your full name for the record?
Joshua Allen Robinson.
Today is the day set for pretrial conference. How are we proceeding?
Mr. Allen Robinson would like to continue his not guilty plea and set this matter for a final pretrial, and we will also like to request discovery. I believe it may have been sent before, but the link may have expired, so we are asking that it be sent again.
The court is going to continue a not guilty plea on behalf of Mr. Allen Robinson, and I will set the matter for final pretrial conference, April the 25th, 2024 at 9:00 a.m. Discovery should be submitted to the defense by March the 25th. The file will continue with no drinking and no driving without a valid license. Anything further?
No, thank you, Your Honor.
Nothing for the defendant.
Then we're all set. Have a great day. Stay safe.
You too.
Thank you. Mr. Torbert, please unmute. Please start your camera. Excuse me. Please start your camera. Mr. Torbert, please start your camera. Ms. Hall, Ms. Hall? Oh, never mind. Okay.
Thank you, man.
All right, I'm ready on Torbert. This is case number 234402101. The people of the state of Michigan versus Jalen Marcel Torbert. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning again, Your Honor. Wright Blake appearing on behalf of Jalen Torbert, P37259.
Mr. Torbert, please unmute and state your name. Please unmute and state your name.
Good morning, Your Honor. Jalen Torbert.
Good morning, and is your middle name Marcel?
Yes, ma'am.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
Judge, is my understanding the complainant was supposed to be present today?
Ms. Ritter?
Your Honor, there was an arraignment on the bench warrant held on November 17th of 2023, and the court did set a pretrial conference for today. The complainant witness was required to appear. I don't see the complainant witness, Mr. Kelvin White, in the waiting room, and the people have no explanation as to why the complainant witness has not appeared for today's pretrial conference. At this time, Your Honor, the people will not be able to proceed based on the complainant witness's failure to appear for today's pretrial conference.
We would move to dismiss, Your Honor.
Okay. Say that again. I'm sorry, Mr. Blake.
We would move to dismiss, Your Honor.
All right, then the court is going to grant defense counsel's motion to dismiss as the complaining witness was required to appear. The people have no explanation for their failure to appear. Mr. Blake, if you could submit an order of dismissal for the court to my clerk, I'll sign it, and then Mr. Torbert, your lawyer, will get a copy to you for your records, okay?
Thank you, Your Honor.
You're welcome. And have a great day. Stay safe.
You as well, Your Honor.
All right, thank you. Ms. Hall. Oh, let me bring in, what was it? We're gonna try Jones again. And then, let me check my email. Ms. Lewis, you're gonna have to get stationary, ma'am. You can't come to court walking around. All right, Mr. Jones and Ms. Lewis, I am going to send you both to the breakout room. Please accept to join the breakout room and wait for a lawyer to come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer. All right, Ms. Hall, are you ready on Harper, Holden, or McGlawn?
I am ready on all of them.
All right. I'm ready on Harper. This is case number 234558501, the people of the state of Michigan versus Quintessa. Comanche Harper. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Quintessa Harper. Ma'am, may you state your full name for the record?
Quintessa Comanche Harper.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in this matter for failure of the complainant to appear. However, if the court is not willing to dismiss this case at this time, we have no objection to an adjourned pretrial requiring the complainant's presence.
Ms. Ritter.
Your Honor, I don't see the complainant witness, Mr. John Ellis, in the waiting room, at least by that name at this time, Your Honor. It is scheduled as a first-time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
The court is going to deny defense counsel's motion to dismiss, granting the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm gonna set the pretrial conference for April the 3rd at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness did not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Nothing for Ms. Harper.
Then we are all set. Ms. Harper, have a great day. Stay safe. I'll see you on April 3rd.
Okay, thank you. You guys have a good day as well.
Thank you.
You're welcome.
All right, I'm ready on Holden. This is case number 08-603-3901, the people of the state of Michigan versus Selena Holden. The defendant is charged with 1 count of assault or assault and battery, 1 count of malicious destruction of property. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Brikidia Hall on behalf of Selena Holden. Ma'am, may you state your full name for the record?
Selena Holden.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of the complainant, and if the court is not inclined to dismiss the matter, we have no objection to an adjourned pretrial requiring the complainant's presence.
Ms. Ritter?
Your Honor, so I don't see the complaining witness, Ms. Sierra Foster, in the waiting room. It is a 2008 case, Judge, and usually the people would ask the court for an adjourned pretrial conference to try and locate the complaining witness. However, Your Honor, in my system, I see that we have notes that the last known address we had on file, the mail came back as returned, and we don't have any other contact information for this complaining witness. So at this time, Your Honor, if the court's inclined to dismiss the matter, the people have no objection to that. If we do hear from the complaining witness in the future, we will consider refiling the case. But at this time, Your Honor, we are unable to locate our complaining witness on this matter.
All right, today is the day set for pretrial conference and the complaining witness has not appeared. People have indicated that they don't have a current address on the complaining witness. The court will also note that in looking at the file and the handwritten register of action, June 18th, strike that. There's no date on here. It was in 2012 though, and it said the complaining witness had failed to appear at that time, and the matter was adjourned to June 18th of 2012. And then for some reason, at that time, Judge Giles also increased the bond to $2,000, 10%. On the adjourned pretrial date, I don't think the defendant or the complainant appeared. So with respect to that, the court is going to grant defense counsel's motion and dismiss the matter without prejudice as the complaining witness cannot be located. Ma'am, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Okay, thank you, Your Honor.
You're welcome. All right, I'm ready on McLawn. All right, Mr. McLaughlin isn't ready. He needs to get stationary. I'm ready on Simmons.
I don't have that.
Mr. Simmons. All right, this is case number 234441301. The people of the state of Michigan versus Darius Tyleek Simmons. Defendant is charged with 2 counts of assault or assault and battery. I'm sorry, Mr. Simmons have on the same shirt he had on when he first came in, and Ms. Stevenson didn't give you the message that I sent it to the.
Judge, I'm sorry. I forgot my phone's not working. I'm sorry.
Oh, okay. Okay, he's charged with 2 counts of assault or assault and battery, but I want you all to recognize violations of the dress code policy on your own and, correct your client's attire. He's charged with 2 counts of assault or assault and battery, and today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakedia Hall on behalf of Darius Simmons. Sir, may you unmute yourself and state your full name for the record?
Darius Tyleek Simmons.
Today is the day set for pretrial conference. How are we proceeding?
Your Honor, this is at least the second scheduling of the pretrial. The complainant is not present. The complainant was required to be present. We are requesting a dismissal for the complainant's failure to appear.
Ms. Ritter?
So, Your Honor, it looks like the court arraigned this matter on a bench warrant and set this pretrial conference requiring the complaining witnesses to be present. I don't see Mr. Christian Harris or Ms. Melisha Rouse in the waiting room, and the people don't have an explanation as to why the complaining witnesses are not present today, as they were required to appear by the court. At this time, Your Honor, the people would not be able to proceed based on the complaining witnesses' failure to appear for today's pretrial conference.
All right, today is the day set for pretrial conference. Neither complaining witness have appeared and they were required to appear. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice, both counts. Sir, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe. We can retry McLaughlin. Does anyone know Hinton? Am I missing that?
I don't have a Hinton on my list, Your Honor.
All right. I'm ready on McLaughlin. This is case number 244402401. The people of the state of Michigan versus Kenneth Lamont McLaughlin. The defendant is charged with 1 count of assault or assault and battery. Today is the day set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakedia Hall on behalf of Kenneth McLaughlin. Sir, may you unmute and state your full name for the record?
Please unmute your device. How many do I have on case third now?
Kenneth Lamont McLaughlin.
Today is the day set for an arraignment, Ms. Hall.
Your Honor, Mr. McLaughlin stands mute and waives the formal reading of the information. We would like to request that this matter be set for a pretrial conference.
Court enters a not guilty plea on behalf of the defendant and set the matter for pretrial conference April 3rd, 2024. At 8:25, ask the bond.
Your Honor, Mr. McLaughlin does not have any KPS history. He is employed as a truck driver, 54 years old, has lived in Michigan his entire life. We are asking for a personal bond. He did Zoom in for his arraignment today, and he understands he has to appear in court and have no contact with the complainant.
Ms. Ritter.
Your Honor, the people have no objection to a personal bond. We are asking for no contact order for the complaining witness, Ms. Camille Funches.
Court is gonna set bond in the amount of $2,000 personal bond, no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
No, thank you, Your Honor.
We're all set until April 3rd at 8:25. Have a great day. Stay safe.
Thank you.
You're welcome. Ready on Starks Harris and Jefferson. Are we, oh no, I don't see Jefferson. We didn't do Jefferson, did we? No. Okay. Mr. Starks Harris, please start your camera. All right, this is case number 234575501, the people versus Devontae Starks Harris. The defendant is charged with 1 count of assault or assault and battery, 1 count of malicious destruction of property. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Devontae Starks Harris. Sir, may you unmute and state your full name for the record?
Devontae Starks Harris.
Today is the day set for pretrial conference. How are we proceeding?
Your Honor, we are requesting a dismissal in the absence of both complainants. If the court is not inclined to dismiss the matter, we have no objection to an adjourned pretrial requiring the complainants to appear.
Ms. Ritter.
Your Honor, so I don't see the complainant witness with respect to both charges, Mr. Willerton Inman, in the waiting room. And it is scheduled as a first-time pretrial conference, Your Honor. So at this time, I will respectfully request the court adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. Court is going to adjourn the pretrial conference to April 4th. At 8:36, the complaining witnesses are required to appear. Failure of the complaining witnesses to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witnesses could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Nothing for Mr. Starks Harris.
All right, then, Mr. Starks. Okay, Mr. Williams is not ready. Mr. Starks Harris, you're all set until April 4th. Have a great day. Stay safe.
Okay, thank you.
You're welcome. All right, are we ready on? I think I'm missing somebody on here. Hold on. So Jefferson, maybe that's, no. And then I got. Okay. Why is Diamond Lewis unattended? And are we waiting on something?
I will go in and speak to her now.
All right, I'm ready on, I need to get ready always. All right, I'm ready on Harrison.
Judge, before we do Harrison, may I have like a quick 2-minute break?
Yes, all right. Mhm. I'm gonna go to the book before I get off here.
Okay. Oh, yes, sir. Okay, I'm ready. All right. All right, you want me to
Good morning, can the person identify with the last name Hinton, please unmute and state your name.
That's you, go ahead. Simi Willoughby.
Mr. Willoughby, your case was at 8:36. Why are you just logging in?
I was in the wrong courtroom.
Ma'am, can I say something? Can I say
What
something?
were you in?
Judge King,
Can you call Judge King's courtroom to see if Mr. Willoughby was in Judge King's courtroom?
Judge Bryant, this is Mr. Henson. I'm Mr. Willoughby's therapist. On the register of actions, it's not showing the court date on here. It says 1/25/24, heard and granted, and then another one of those. The next one it shows on here is final conference with.
Mr. Willoughby, Judge King's clerk said you have not been in their courtroom. Who identified you in the courtroom? Unmute yourself, please. Mr. Willoughby, unmute yourself.
Go ahead.
Miss Owens, the counselor lady wanted to put me in the courtroom.
And then at what point did you realize you were in the wrong courtroom? Judge King's court said you-
I kept telling them that I was supposed to see a lady, that it wasn't supposed to be Mr. King. But they didn't know which one to go to because on the paper it got Judge King name on it.
And there's no date for their
And they don't have no date. You don't have no court date for this date.
the register of actions.
On the register of actions,
There's no date.
there's
Well,
no.
Mr. Willoughby, I know your therapist is talking to you, but I need Mr. Willoughby to attend court.
Yes, ma'am.
I need Mr. Willoughby to attend court. And Mr. Willoughby, the last time you were in court, we told you your court date.
I did.
We gave you information. We told you what judge it was. So I don't know where you got the register of action from, but the register of action does not replace the information that you got on the date of your court hearing. I'm gonna put you in a breakout room to talk with a lawyer. But you're very late for court, and there's no reason for you to have been in the wrong courtroom.
I don't know how to read and write. I didn't know which one to go to. That's why I didn't know what I was doing.
Well, I don't know why you did.
I knew.
Mr. Willoughby, let's not have a back and forth. Let's not. I'm gonna send you to the breakout room and a lawyer will be in to speak with you. Please accept to join the breakout room and wait for the lawyer to come in to speak with you.
All right, thank you.
Can the person on the non-video telephone with the phone number ends in 8827, please unmute and state your name for me. Press *6 to unmute and state your name for me.
Hi, my name is Robert Plunk.
Say that again, please.
Robert Plunk.
Mr. Plunk, you've been here before, and so you know that you have to be on video.
Yes, I'm actually on a coworker's phone. AT&T is down. I sent the pictures to my lawyer.
Yeah, I know AT&T is down. I know AT&T is down, but what's not down is public transportation. So if AT&T is down and you knew you needed AT&T to attend court, then you were supposed to come in person. So what's not down is public transportation and Lyfts and Ubers. But you cannot attend court on this non-video device. I'll send you to a breakout room. You can talk to the lawyers, but this is your final pretrial before your trial date. So certainly you were gonna come to court in person when you realized that you could not come in court on the video. I'll send your device to a breakout room And Ms. Stevenson will be in to speak with you shortly.
Okay.
This is case number 214439301. People of the state of Michigan versus Latoya Harrison. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Latoya Harrison. Ms. Harrison, ma'am, please unmute and say your full name.
LaSoya Sierra Harrison.
Today is the day set for sentencing. And I need to know why Ms. Harrison didn't participate in the pre-sentence investigation before we proceed.
Your Honor, Ms. Harrison was not contacted by the probation department, Your Honor. I think for the second time, I did notice from the PSI that the phone number is unknown. And I don't understand that, Your Honor. I did forward contact information to for Ms. Harrison on the date of her sentencing. So Ms. Harrison, I don't know why the probation department did not contact her. Yes, Your Honor.
You forwarded contact information to who?
Let me see. I think I emailed the courtroom as I customarily do, Your Honor.
Okay, and then what happened when they sent the letter to the address on Beaconsfield?
That's not the address that I gave them. I gave them a more recent address where she receives her mail.
And then when she never got in contact after the first time that this happened, and then nobody contacted her, at what point did she contact you?
So Ms. Harrison, because I can't pull up my messages right now. I know that she did contact me after the first sentencing date was missed. And I can't see the messages right now, Judge, so I don't know.
Well, because I'm confused. So, because what we're not going to do is keep coming to court on the day of court addressing issues. We're not. And the penalty is going to go to the defendant. So that's why it's important. So if we already adjourned the sentencing because we couldn't reach a person. And then we get some new information and I suppose, send it to probation. So that's my next question. But then everybody knows, if Ms. Harrison knows and Ms. Stevenson knows that probation did not contact Ms. Harrison, on the day of sentencing is not the time to alert the court that probation didn't contact Ms. Harrison. The day of sentencing is not the time.
I understand, Your Honor.
Did we send the new email address to probation?
You received an email November 9th where information was sent.
But did we send it to probation? When we sent the referral to probation, shouldn't it have had the new updated information since it was the second referral to probation? It was the second referral to probation.
316. No, on January 16th. That was.
All right, I need us to make sure that I can't do this. But what I also need is for information to get to the court before there's nothing I can do today. Nothing there. I can do nothing. I can't calling Mr. Farmer today means nothing. But I'm gonna go ahead with the sentencing, and it's unfortunate because this case needed a pre-sentence investigation, and it needed for me to be able to see a full picture because I'm appalled at what I read. Let me just say this. I'm appalled at what I read I'm just appalled. So let's go. All right. With respect to the pre-sentence report, on behalf of the people, are there any additions, deletions, or corrections?
None on behalf of the people, Your Honor.
And on behalf of the defense, other than sitting here and giving me a whole entire pre-sentence investigation report, are there any additions, deletions, or corrections?
Yes, Your Honor. Ms. Harrison and I have had the opportunity to review the pre-sentence investigation report, Your Honor. I do have additions to offer to the court, Your Honor. Some of the information has been that Ms. Lurch was able to gather, but I do have some additional information for the court. To summarize, I would advise the court that the address that's been provided that's listed, in fact, as the current address, even though that's different than the address on the face sheet, is an address where Ms. Harrison receives mail, but she does not have a place to live at this time, Your Honor. She actually it has just started working on January 14th at Amazon, and they're letting her sleep there, Judge. She had been sleeping in her automobile until she had an accident on January 14th, totaling that car, which coincidentally is the same day she still managed to get that job at Amazon as a team assistant. She has not been in the military, but she did finish high school in 2009 and did further her education at Macomb Community College and Wayne County Community College. In addition, she did receive a CNA certificate. She had to submit her condition of pre-employment runner. She got the job, so she tested negative. They would not have hired her, tested positive for any prohibited substances. She's never been in any treatment program. She is under the care of physicians for the car accident that she suffered in January 14th of 2024. And she does have past mental health diagnoses, Your Honor. She has not been able to treat with her therapist because she has not had transportation. Ms. Harrison's family, for the most part, Your Honor, does reside in the state of Georgia. She has been adamant about trying to get this matter resolved because failure to do so has interfered with her ability to work in her the field in which she's trained. She did get a job, so she would be able to comply with what we hope would be conditions of probation for a delayed sentence. I would ask the court, I believe that the sentencing recommendation that's been prepared by Ms. Lurch, except for the outpatient treatment, and except for the prohibition against the consumption of alcohol, to be an appropriate sentencing recommendation. I would ask the court, if at all possible, that Ms. Harrison be supervised by probation officer MIBryant, because I think Ms. McCall could put Ms. Harrison in touch with some resources that she really, really desperately needs at this time. There is, again, I would not have an objection to the mental health evaluation. And if that were, and that Ms. Harrison just be ordered to follow through with any treatment recommendations, and just keep on the table a possibility if we get to that point of this matter being referred to the mental health court. I don't think I don't think that that's warranted right now. But Ms. Harrison does not have any contact with the complaining witness. There was no restitution that was ordered. Ms. Harrison,
Are you correcting the report or are you allocating about sentencing?
I think I may have crossed that line, Your Honor. So, and I thank you for correcting me. So with regard to, other than the contact information, Your Honor, those are the only, other than the contact information which we have supplied, those are the only corrections that we have at this time. Thank you, Your Honor, for stopping me.
All right, Ms. Ritter, anything with respect to sentencing?
Judge, with respect to sentencing, there was a sentencing agreement that had recommendations by the people. The people did recommend 12 weeks of anger management classes, no contact with the victim, Ms. Soandra Hardwick, restitution, if any, and delayed sentence if Ms. Harrison was eligible for that. Looking at page 4, Your Honor, looks like probation did not receive a response from the victim. People did try to reach out to the victim back in January, I believe it was January 3rd, and was unable to speak with the victim regarding any restitution payments for any out-of-pocket medical expenses. So we don't have that information as of right now. But other than that, Judge, I will leave everything else under the discretion of the court.
All right, Ms. Stevenson.
Thank you, Your Honor. And as I think I started already saying, I am asked, it was a no contest plea, Your Honor, and Ms. Harrison is nonetheless ready to accept responsibility for some bad decision making that she made on the date of this incident. I believe that the sentencing recommendation, again, except for the outpatient treatment and the prohibition against consumption of alcohol to be warranted. Ms. Harrison is really trying to work and get some shelter. So I would ask for a reduced rate for any supervision fees that the court might order. Again, absolutely no contact between the parties. It is to Ms. Harrison's credit that she doesn't have any prior criminal history, that her license is good. She doesn't owe has no outstanding obligation to the 36th District Court or any other jurisdictions that I'm aware of. I don't know, how we got to this place right now with the court not having more information directly from the probation department. But, certainly if Ms. Harrison, had transportation, maybe she could have moved around a little bit more. Maybe if she wasn't, struggling with homelessness, maybe she could have, been a little bit more proactive, but she has reached out to counsel, Your Honor. I just can't get the court the exact information as to when she did that. But Ms. Harrison has not by any means, been ghost. She's not ignoring this situation at all. She's been cooperative with me throughout the entire process. She's really, I'm surprised with everything that she's been through, that she's still here trying to keep it together, because unfortunately I know a lot of people who haven't been able to do that. So she's trying, Judge. I would ask for the support of 36th District Court Probation Officer MIBryant to help Ms. Harrison access some services that I think she really needs right now.
Will Ms. Harrison like to make any statement on her own behalf?
Ms. Harrison, do you want to say anything? You have to unmute.
Thank you. Your Honor, I just want to say I apologize for this whole situation and to just waste your time with the situation. I apologize for the actions that I took, and I'm just here to make a better situation out of this whole thing. It's been a long, drawn out nightmare that I've never been in before. I've never been in any type of trouble before. Like she said, I'm a caregiver, and I've been helping taking care of people my whole life. Never been in a situation like this. And I'm sorry that this even happened. And I'm just asking for this.
I'm sorry, what did you say?
I was asking for the mercy of the court. That's it, Your Honor.
Okay. The court has had an opportunity to review the pre-sentence report. I'm ready to impose sentence. And I think I gave a speech this morning to another person I sentenced about their behavior when I read the pre-sentence report and the description of what occurred. And I was saying that sometimes we make mistakes and sometimes we make horrible decisions. And again, this was a horrible decision. And I can't even imagine where I would be today. I know where I wouldn't be today. I know where I wouldn't be sitting right here where I'm sitting today. If one of my children had even tried to argue with me when I told them they couldn't go somewhere. Right. So did you hear me say, if they had even argued with me and I told them they couldn't go somewhere, let alone fight with me. And then if I read the report correctly, so I was trying to follow the dots. So if I read the report correctly, Ms. Harrison is the sister of the victim's daughter. And so I don't have that situation where my children have any siblings that are not born to me. I don't have that situation. However, I don't care who was, their cousin, their friend. If I told my kids they couldn't go somewhere, I wish somebody would come and try to pick them up. Right? Where I know I wouldn't be is here because I would be disqualified from being here. And I would probably have been somewhere in your position with the state of Michigan versus me. So somebody coming to pick up somebody's child who's been told they can't go somewhere and then attacking the person who said that the person couldn't go somewhere is beyond my comprehension. It's beyond my comprehension. And then sometimes we make choices that put ourselves in bad situations. So Ms. Harrison made a choice that has now put her in a bad situation where she can't even like go and be with her support system. Where apparently her support system is in another state. And so she couldn't go and be with her support system. It looks like there are some people out there with enough heart to try to help her get out of her current situation based upon what you've said to me about her living situation and that sort of thing. I don't want anybody to ever not have a place to go. I don't want anybody to ever not have a place to go. I don't ever want I wish I could just wave my hand and homelessness would disappear. It's not that easy. So, as I said, when I was trying to figure out what happened with the pre-sentence investigation, I don't like what I read in here. I do not like it. I don't like it. I don't like what I read. And I don't know why Ms. McKinney, I think is her name? No, Ms. Hardwick. I don't know why Ms. Hardwick, didn't want to she didn't give any information with respect to restitution, and maybe there was none. And she didn't appear today to make the victim impact statement. But you were wrong on so many levels. You were wrong on so many levels. And I don't know where the daughter is that participated, but if she still live with Ms. Hardwick, that's amazing to me. I was going to increase everything I saw on this. I was going to increase everything I saw. I was going to increase it to 24 months. I was going to increase it to 24 weeks of intervention. I was going to I was gonna increase it to everything I saw. I don't know that it's all the way your fault. Well, I do know, it's not all the way your fault that that your input was not gotten for the pre-sentence investigation. It is a failure of the system, though. It is a failure. It's a failure of this courtroom, it's a failure of the defender's office, and it's a failure of probation. With those three things working together, we should not be here another day without a pre-sentence investigation. We should not. When the referral was sent to probation, if they couldn't reach her, then they should have contacted the court. They should have contacted the courtroom, they should have contacted the lawyer. It's ridiculous. When the lawyer got notification that the pre-sentence investigation wasn't done, the lawyer should contact the courtroom, contact probation. There is a way for us not to end up here, but we keep ending up here. And I suppose that means there's a meeting to be had, but we keep ending up here. I have an opportunity to listen to you, Ms. Harrison, and as I said, I believe in giving chances, but you all are making horrible decisions. You're just making horrible decisions, and it's not even necessary. And I don't know why it was so important for Corleia to leave the house and attend a party, but she must be blessed to have a mother she has. She must be blessed to have a mother she has. You can put your hand down because it's my turn and my turn only to talk. Because I don't care where she was going or what she was doing or who was celebrating or what the occasion was. I don't even know how old she was, but if she lived in my house, as for me and my house, we're all gonna follow my rules. Otherwise, you're grown and you get out so that you can make your own rules in your own home where you pay the bills and run the heat and the air conditioning and pay the electricity and the heating bill and the Wi-Fi. In your own home, there is no curfew unless you set one. In your own home, you can leave the refrigerator door wide open. In your own home, you can wash one piece of clothes if you want to put one piece of clothes in the washer in the place where you live and pay the bills. So if I live here and I'm the bill payer and I say, can't nobody leave out of my house on Tuesdays. If you try to leave out the house on Tuesdays, you got to get out and get your own place. And I promise you, if you keep looking right now, like I'm getting on your nerves, if you keep looking right now, like you don't want to hear what I got to say, if you keep looking like that, I'm going to change my mind. Keep playing with your hair. And grace and mercy will leave out this room. It's not a party in the world important enough for my child to attack me. I want to send Ms. Harrison to breakout room number 5. Ms. Dixon, you go talk to her because I'm getting ready to change my mind. All right, I'm ready on. Ms. Hall, what are you ready on?
Your Honor, I am ready on everything.
Okay, well then let's see. Let's go Willoughby. Ms. Hall, the only one be saying I'm ready on everything. I like Ms. Hall. I'm ready on Willoughby. This is case number 22. Oh, no, I'm not ready on Willoughby. Mr. Willoughby was the one late. Hold on, I gotta do the other people first. Are you ready on Williams and Jones?
Yes, Your Honor.
Okay. Let's do, Williams and Jones, and then what about, and Lewis, okay. Well, let's see if Jones is ready. All right, this is case number, 204552701, the people versus Kendall Martez Jones. Defendant is charged with one count of assault or assault battery, and today's the day set for review. Appearance, please.
Rakedia Hall on behalf of Kendall Jones. Sir, may you unmute and state your full name for the record?
Bill Martez Jones.
And Bill, thank you. Today's the day set for review, and according to probation, Mr. Jones was placed on probation a year ago, and it was for 12 months, a little over a year ago. This is, his term was supposed to end on the 16th of this month. But he has completed all the terms and conditions of his probation, and in fact, probation did submit a discharge order. Mr. Jones, do you want me to discharge or you want to keep going?
I'll take the discharge, Your Honor.
I'll take it too. Let's go with door number one. All right, Mr. Jones, great job, and okay. I am going to discharge you from probation with improvement. What is discharge? I'm sorry. I don't have my notes for Mr. Jones. Was he? This wasn't a, oh yeah, this was a delayed sentence. It's a delayed sentence. So, Mr. Jones, in addition to discharging you from probation, I am going to dismiss the matter with prejudice pursuant to 771.1. We will remove the conviction from your record. You're no longer convicted of this assault and battery. The case is closed with improvement.
Thank you, Your Honor.
You're welcome. We will mail a copy of those orders to you for your record, sir. Have a great day and stay safe.
You as well. Thank you.
You're welcome. Okay, I'm ready on. You're ready on Ingram too? You said you're ready on Ingram?
Yes, Your Honor. Everyone with the plus sign.
All right, this is case number 116623401, the people versus Kimberly Renee Ingram. Defendant is charged with operating with a high BAC, driving while license suspended, revoked, denied. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina.
Ms. Ingram, please do not unmute yourself unless asked to do so by the court. You keep unmuting yourself and you're giving us a lot of feedback. Ms. Ritter?
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakedia Hall on behalf of Kimberly Ingram. Ma'am, may you unmute and say your full name for the record?
Kimberly Renee Ingram.
Okay. Today's the day set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Ingram would like to continue her not guilty plea and set this matter for a jury trial.
Are the people able to proceed?
So, Your Honor, it looks like the arresting trooper is still present with MSP, so at this time, we are ready to proceed.
Court continues a not guilty plea on behalf of Ms. Ingram, set the matter for jury trial. October 15th.
None.
Court is gonna set the matter for October the 15th. At 10:30 a.m. with a final pretrial conference. September the 27th. Ms. Ritter, although the trooper is still on the force, you need to contact the trooper, by this final pretrial conference to make sure they're not going, well, really, you need to contact the trooper to make sure that that's not their, winter furlough day. Cause I'm not changing the date once we get all the way to, up to the trial.
Understood, Judge. The people will do that.
The final pretrial conference is at 9:10. Anything further?
Not for the people, Judge. Thank you.
Nothing for Ms. Ingram.
All right, Ms. Ingram, you're all set. Have a great day. Stay safe.
Thank you. You too.
Thank you. Mr. Williams, please start your camera.
Yes, ma'am.
This is case number 234521701, the people of the state of Michigan versus Edward Williams. Defendant is charged with 1 count of weapons discharged, while aimed without malice, and today is the date set for a final pretrial conference. Of appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and Judge, it's aimed without malice with injury.
Okay. With some injury.
Yes.
Rakidia Hall on behalf of Edward Williams. Sir, may you state your full name for the record?
Edward Williams.
Today's date set for final pretrial conference. How are we proceeding?
Mr. Williams would like to continue his not guilty plea and set this matter for a jury trial.
I'm looking at the complaint. How are the parties, how are the individuals related?
Your Honor, according to the investigator's report, the parties are father and son.
So then why do I have it? Why are we at a final pretrial conference and I have the case?
Well, Your Honor, if I may, due to the nature of the charge, the people didn't bring that to the court's attention because the people intended on keeping the case opposed to transferring.
What? You're not even getting ready to be here. You been ready to be gone to another thing, and she said, Judge, I wanted this case. Did y'all hear her say that? You better tell me, you're not even gonna be here to try this case, Ms. Ritter.
Well, Judge, at the time, that was the people's intention, so if the court wants to transfer a judge, I mean,
I am definitely transferring the case. But let's see, the court is gonna continue, call Judge Garrett's courtroom. Court is gonna continue a not guilty plea. And, let's see, we've already gotten to the trial stage. I'll see if Judge Garrett wants me to go ahead and give it a jury trial date. Who is that?
Next door, TC.
I really want, I probably should talk to Judge Garrett. Is he here?
He's gone.
Let me find out what he wants me to do, then we can call her back. Oh, my phone ain't gonna work. Does he have AT&T? We can't even communicate. She does, let me try to call him from, let's see. I'll try to call him from the court's phone and see, I'll call her back. AT&T need to fix their stuff. Okay.
I'll call you back.
I'm good. Question. Who am I here today? Right. So I have a case that I've just discovered should be yours. It's a father and son. And the charge is, the charge is weapons, firearms, discharge while being without malice to intent. But the defendant is the father. Is the defendant the father or the son?
The father, Your Honor.
Okay. The defendant is the father. Is when I got here today for a final conference. He's still. So I was gonna send it to you, but I wanted to know, what did you want me to set it for? And did you want me to, how quickly did you want me to send it to you? Next Thursday for final pre-trial conference. Okay, all right, and then now the complaint has been already appeared for me, so are you requiring him? Okay. Okay, all right, thanks. Okay. Okay, let Leticia know the judge said next Thursday. Okay, I am going to continue the not guilty plea and also transfer the case to its proper location before Judge Austin Garrett, who has indicated that he will hear the final pretrial conference next Thursday, which is on February the 29th. Oh, he didn't give me a time. What time does he put his final pretrial?
Okay. 9 a.m. complaint is not there. 9:30. Complaint is required.
Okay, no, 9 o'clock then. Okay, 9 o'clock. All right, so sir, you're gonna log into Judge Austin Garrett next Thursday, February 29th at 9 o'clock. How did you log into my courtroom meeting? Did you use my name or did you use my Zoom ID number? Unmute yourself. And I think you said you used my Zoom ID, but unmute.
I'm sorry. Yes, ma'am. I used the ID number.
Okay, so Judge Garrett's ID number is almost identical. Where you see a 9 in that ID number, just change it to an 8.
Yes, ma'am.
All right, and then he indicated that next week, when you appear for the final pretrial conference, then he'll give you a jury trial date at that time.
Yes, ma'am.
All right, Bond will continue. Anything further?
No, thank you, Your Honor.
Nothing for Mr. Williams.
Then we're all set, sir. Have a great day. Stay safe.
Thank you, ma'am. You all as well.
Thank you. Okay, I'm ready on Lewis. And then Willoughby. And then Harrison. All right, this is case number 194596001, the People versus Diamond Page Lewis. Defendant is charged with 1 count of child abuse, fourth degree. Today is the day set for review. Appearance, please.
Rakidia Hall on behalf of Diamond Lewis. Ma'am, may you unmute and state your full name for the record?
Diamond Page Lewis.
Today is the day set for review. Ms. Lewis was placed on probation by this court in October of 2022. She was placed on a non-reporting probation. I'm immediately changing it to reporting because she's done nothing. She's done nothing, and so I'm immediately changing the probation to reporting. We're gonna do an amended order, and it's just gonna indicate that she now has to report. That also means that, where's her? Oh, Miss Hall, let me hear what, if you have anything to say.
Yes, Your Honor. I would actually ask the court to schedule another review in a couple months and then determine whether Ms. Lewis should be reporting. She has taken the marijuana class with eBay. She has to, she did speak with Ms. Tucker yesterday. She has to get the information over to Ms. Tucker, and she just got in the financial position to be able to afford the parenting classes and start making payments. She is taking seriously. She does want to get everything complete. However, given the economy and her current circumstances, she wasn't able to afford to do the classes, but she is able to now, over the course of the next 12 weeks, take the parenting classes and to make payments in terms of the fees owed to the court.
Okay, and you realize that if she doesn't complete the probation within 12 months, she can't get delayed sentence.
Yes, Your Honor, and I did explain that to her, and it is her intention and desire to take full, to be able to use the delayed sentence. So she does have intention to complete the delayed sentence before October of 2024.
All right, and I'll reserve the reporting until the next review, and I will set another review for, let's go to May, which I think will be her halfway point, but let's go to May. Actually, I can't do May. Let's do June 5th. How many do I have? Let's do June 5th. If she still hasn't done anything, she's gonna go to reporting probation.
Thank you so much, Your Honor. And I do have full faith that Ms. Lewis will make some progress between now and then and hopefully be finished.
All right, well, and if you said she did do the, which class did you say she did?
The marijuana course through eBay.
All right, as long as she turns that, certificate over to Ms. Tucker, and then, her review is gonna be at 10 o'clock. All right, anything further?
Nothing further. Thank you, Your Honor.
All right, Ms. Lewis, you're all set until June 5th, all right? And then, you're not, you're still early on in the probation, so I'm not, penalizing you, but if it looks like you need guidance, somebody to help you, make sure you're doing the classes, then that's why I'm saying I would change it to reporting. There's no penalty for not finishing early. Okay?
Yes, ma'am.
All right, you're all set. Have a great day. Stay safe.
Thank you.
All right. Okay, I'm ready on Willoughby. This is case number. Did we get in touch with Tierra? Did anybody call Tierra and see if she could come in the morning? Miss Stevenson not on here. Let's tell Miss Stevenson. Okay, I'm ready on Willoughby case number 224416301, the people versus Semi Floyd Willoughby. The defendant is charged with 2 counts of assault or assault battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Rakidia Hall on behalf of Semi Willoughby. Sir, can you state your full name for the record?
Semi Floyd Willoughby.
Today is the date set for pretrial conference. How are we proceeding?
Your Honor, this is at least the second scheduling of this pretrial conference. The complainant was required to appear. The complainant is not present. We are requesting a dismissal and the complainant is absent.
Ms. Ritter?
Your Honor, it is at least the second scheduling of the pretrial conference. The court required the complaining witnesses, Mr. Randy Bailey and Mr. DeMarco Dembo, to be present. I don't see either of those complaining witnesses in the waiting room. The people have no explanation as to why the complaining witnesses are not present. So at this time, Your Honor, the people will not be able to proceed based on the complaining witnesses' failure to appear for at least the second scheduling of the pretrial conference.
The court is going to grant defense counsel's motion and dismiss the matters without prejudice. Today is the date set for the pretrial conferences. It is at least the second scheduling, and the complaining witnesses have failed to appear. People have no explanation for those failures, and they are unable to proceed. Mr. Willoughby, we will mail you a copy of the order of dismissal for your records. Unless there's something else for the record, we're all set.
No, thank you, Your Honor. Thank you.
Nothing for Mr. Willoughby. Thank you, Your Honor.
All right, you're all set. Have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. Ms. Stevenson.
Yes, Judge.
Oh, your phone not working, like mine. Oh, but you have, phone numbers for your clients. Did I already ask you to try to call, Ms. Allman?
You try to call who, Judge?
No, I said, did I ask you to try to call Ms. Allman? Did I ask you that?
No, but I can.
All right, let's try to call Ms. Allman. And then what's the situation with Mr. Plunk? I know, let's just go ahead and finish Ms. Harrison, because Mr. Plunk is in a little predicament.
Can he come in tomorrow morning, Your Honor? In person?
Let me see my doctor. I'm ready on Harrison, please. All right, I'm ready on Harrison. Okay, so I don't even remember where I left off, but oh, I guess so. Ms. Stevenson.
Thank you, Judge.
All right, so I am, despite what I believe to be true, I'm going to accept the recommendation from probation. And I'm going to impose 12 months probation. With a final review of February 24th, 2025, a midway review of August 22nd, 2024. The August 22nd will be heard at 1:30 p.m. Court imposes the following fines, costs, and fees. I'm gonna go ahead also and say it's a delayed sentence, but I might change my mind. If I don't think this delayed sentence is gonna be deserving, I'm gonna change my mind, because an individual to get a delayed sentence has to show some type of contriteness. And, all right, so right now it is a delayed sentence. And the court is gonna impose the terms and conditions are that you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis and notify probation immediately of any change of address, phone number, or employment status. Now, I tried to ask Ms. Lurz why there are two different addresses on the report. She says one address is from the Secretary of State and one address was from the Register of Action. And I don't know why the Register of Action still reflects the old address when the address was updated. So that's an issue for me. But she also says that the notice was sent to both addresses. So if notice was sent to both addresses, then the notice should have been received. If there's a place that Ms. Harrison needs to receive her mail other than those addresses, then we need to be notified immediately, because not getting the mail that was sent to an address on record is not an excuse. Court is going to impose a mandatory cost of $210, a $50 attorney's fee, a $300 fine, $420 in supervision fees at a rate of $35 a month, a $50 pre-sentence investigation fee. She has to submit to drug testing for 3 months. And if the court is satisfied with the results, the testing can be discontinued. I'm going to impose $30 for testing, and that is if the tests are conducted at 36 District Court. If they are not, then they have to, the fee is going to be paid directly to the agency. Total fines, costs, and fees are $1,060. Of that amount, $850 has to be paid in order to get discharged early. Of course, that is unless the court converts any portion to community service. You shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription. You shall not drive without a valid driver's license. Shall complete 12 weeks of anger management. Have no contact with the complaining witness. Pay any outstanding tickets with 36 District Court, which the report says there are 0. Provide proof of education or participate in an adult education program. Submit to a mental health evaluation and follow any recommendations. Court will place in the order that case should be assigned to Ms. McCall. And I think I'm not gonna order outpatient treatment at this time. That doesn't seem appropriate at the moment, and I'm not gonna order no alcohol. According to the report, Ms. Harrison is well above the legal age for drinking alcohol. I'm also gonna hold in abeyance and not order the 3 days of community service at this time, in case she does need her fines, costs, and fees converted to community service, that I might include it at that time, but other than that, I won't. Anything else?
Not on behalf of the people, Your Honor. Thank you.
We thank the court very much, Your Honor. We would ask the court to, if once Ms. Harrison gets connected to Ms. McCall, if she has permission to travel only to and from the state of Georgia, so that her grandparents are not doing so well right now. She has not been able to see them at all. So we just asked for permission to travel to the state of Georgia, Your Honor.
I thought I had already, this is not the case where I gave permission to travel and then y'all said you didn't want it, or I said something about you. This is not that case. I might be. You never asked me about going to Georgia before?
Checking right now. No.
Oh, okay. She can travel to Georgia.
Thank you, Your Honor.
She can live in Georgia if she wants to, as long as she can do the probation from Georgia.
Understood, Your Honor. Other than that, we don't have anything else at this time, and we thank the court. We thank the people.
All right, then we're going. So, Ms. Stevenson. So
yes, sir.
Which address are we mailing the order to? We're mailing the order to the address on page 5?
Correct, Your Honor.
Okay, and is that the address that should be in the system?
Yes, it is, Your Honor.
All right, then we're all set.
Thank you, Your Honor. Take care, Toya. Want to go back to breakout, or are you okay? I can't.
Yes, please take me to the breakout room.
Okay, because it won't work. Your questions now.
I'll put her back. I'll put her into. I think if this is Mr. What's his name on that phone, just tell him yes, he comes along morning in person.
Okay.
Because he's no longer in the breakout room. The person that was on the phone, they're no longer in the breakout room.